All right, we are on the record. We have motions. I think the primary one we're going to deal with this morning is the reinstatement of the third-degree murder charge. And so who would like to speak to that issue first?
Good morning, Your Honor. Mr. Cahill will be addressing the court on that matter.
All right, let me give my understanding where we're at. I had denied the motion to reinstate, saying that the Noor case was not precedential at that time, and that was the sole reason for the denial of the motion. That was appealed to the Court of Appeals, which said no, it had immediate precedential value. Judgment had not been entered yet. Petition for review is taken by the defendant. The Supreme Court has denied review, remanded it back to the Court of Appeals, who then entered judgment. So judgment has been entered on the appeal in this case, so I think we can address the merits. So Mr. Catchall, if you would.
Thank you, Judge Cahill. May it please the court, we really appreciate the opportunity to be here. And you've already said in your last order, you said, quote, if Noor is precedential, this court would now be duty-bound to follow it and grant the state's motion to reinstate murder in the third-degree charge. And that's what we're asking for at this point. Mr. Nelson made two arguments before to argue against that. One was that Noor wasn't precedential, and the second was that there were some differences in the facts. Any other arguments about prejudice we think are well forfeited at this point. Our initial motion to amend the complaint had pages 8 to 10 were all about how there wouldn't be any prejudice, and Mr. Nelson chose not to contest any of that. So really, I think it's a very straightforward decision. State versus Bloom and other cases from the Minnesota Supreme Court say that this court is relatively free to permit amendments to charge additional offenses until jeopardy is attached, until the jury is sworn. And, that's obviously not happened here. And so we think you have the absolute discretion to add this charge, and we think you should. It reflects the gravity of the offenses.
I do believe the Court of Appeals did, however, remand it for the defense to bring on any other grounds they think I could use to deny it. So, Mr. Nelson, I'm going to actually ask that you be at the lectern.
Your Honor, is there, I don't know, is there a way I can turn this monitor off for some, because this is all very distracting, and I'm sorry.
I think you can just turn it down a bit.
This one?
Don't close it, but...
Is that okay?
Does that work?
Okay. Yes, Your Honor, I believe that there are three bases under which the court could deny the state's motion. First and foremost, what I would note is that this case is both procedurally and factually different. Ultimately, what the Court of Appeals said in the opinion for this case, in Chauvin, is that if it's precedential, it has to be applied consistently to procedurally and factually similar cases. So there's a question of the distinguishment between Noor and that line of cases and the facts of this particular case. That's one ground, and I can address that in a second. The second is that I'm raising the question, and we raised it in our response at the Court of Appeals, of the ex post facto application of Noor. Third, Your Honor, under Baxter, this court just has the housekeeping ability to deny. So, addressing the first issue first, we have to remember that Noor, what Chauvin says is that Noor is precedential, but there is still the Fabio versus Bellamo case, which says that once the Supreme Court grants review of a case, it limits the precedential value. Fabio versus Bellamo says once the Supreme Court has granted the petition for further review, that case is of minimal precedential value. So you have that to start with. So the question is this case factually or procedurally different than the Noor case? And they're completely different. What we've seen in these lines of third-degree murder cases is really two lines that have come. you've got the Noor, the Middich, and the Hall cases, which are all cases that look at whether there was sufficiency of the evidence from a post-conviction standpoint. That's one line of cases. You have a second line of cases, the Zumberge, Lineweber, Hansen, that whole line of cases that look at and analyze whether third degree is appropriate as a lesser included, right? And so you have these two lines of cases. Ultimately, looking at the Noor line of cases, where there's a conviction, it's a much different standard than the appeal or than the lesser included standard.
But Mr. Nelson, aren't I pretty much restricted? The Court of Appeals specifically remanded to this court with instructions that I make a decision consistent with their opinion.
So say in the Chauvin decision that you are bound to, or you are permitted to review other issues, right? And the question is, and what Chauvin says is, if it's precedential, right? It's precedential. That question has been answered at this point. Is it factually or procedurally similar?
Okay.
Right?
Go ahead.
And so under Noor, if you look at the facts of Noor, it's a Minneapolis police officer. This is a case involving a former Minneapolis police officer. And that's about where the similarities end. And if you look at the line of cases, Noor, Middich, Hall, all three of those cases, there's some sort of an instrumentality that is used, a gun or a car, generally speaking. Those items could be viewed as inherently dangerous. So in Noor, right, they're saying, what I understand Noor to stand for is the single person rule, and whether a single person can be the focus of the third degree murder. But in the Noor case, Mr. Noor shot his gun across his partner's chest towards a silhouette that could have been anyone or anything. They just saw this biker. Anybody within the line of travel of that bullet was put at risk. It happened to be a single person that was there. And I think that that's significantly different factually from what is alleged in this particular case. They are alleging that my client did not do something inherently dangerous. It was focused on a single person. So factually, these cases are considerably different. Ultimately, they're very different procedurally as well. Because again, Noor, Middich, Hall, those were all post-conviction appeals to look at the sufficiency of the evidence. Procedurally, we are pre-trial. This is a motion to amend the complaint. And it's similar, it's a similar standard, the abuse of discretion standard for this court, to determine whether a lesser included should be added, right? So we're procedurally more consistent in the Zumberge line of cases, right? So that's number one. Then we have the ex post facto. Sorry.
I think they are different, Nora, in this case. I said so in the original probable cause order. Said we could understand how Nora falls under third degree murder because firing a gun out the window endangered not just the person who was killed, but also that officer's partner, biker who was going past at the same time. And so that was clearly fit in the universe of depraved mind, danger to others, plural.
Right.
And I think the distinction we made in the original probable cause order last fall was this is a different case. It is more focused on a single person. And clearly I said the single person rule applies or doesn't apply depending on how you state the rule. And basically there has to be more than one person endangered by the conduct. The Court of Appeals in Norris said they did not take the route of saying we don't have to reach the single person rule because it did endanger others, not just the victim who was shot. They didn't take that route. I think they didn't have to, but they didn't. They said single person rule. When the animus is directed at a single person, that's enough. It falls within the gambit of a third degree murder charge. So I agree they are different cases, but it seems if anything, this is more the single person rule application, even more than Noor. And I'm not sure why they felt the need to decide it that way, but I'm not questioning the Court of Appeals.
Well, I
this
mean,
time.
and that ultimately what the Court of Appeals reversed on in this particular case was a very narrow, very narrow inquiry, which was simply the question of the precedential nature of their opinion and whether you were duty bound to follow it. But again, you are still able to analyze the case from the facts, right? Because that's what the Chauvin case says. The Chauvin case, the Chauvin Court of Appeals decision, specifically says that you're duty bound to apply precedent provided it is a factually similar case, right? And that's, so inherent in that is your discretion to say, this is not a factually similar case. This is a distinguishable case. Whether you apply the one person or the single person rule, it's immaterial, is factually significantly different. And so that wouldn't apply. But if you go back over then and look at that other line of cases, the Zumberge line of cases, and you look at what are the differences between these two types of lines of cases. Well, again, in Knorr, it was a gun. It's inherently dangerous. In Middich, it was a gun. In Hall, it was a car being driven recklessly into some person or into any random other car. In all of the other cases, it's really much more of a focus on, it was obviously the defendants seeking a lesser included, but they distinguish, they're able to factually distinguish. Even though there was a gun, you pull up a gun and you shoot it at a crowd. They're all instrumentalities. Factually, there is no instrumentality here other than arguably Mr. Chauvin's knee, which is not inherently dangerous, right? So that's, I think, the main factual distinction, and what gives this court, what the Chauvin opinion says, you're not duty bound to follow it if it's factually distinguishable. So that's the sum total of that argument, and I'm happy to. So the second issue is this concept of ex post facto, right? And ex post facto under Weaver versus Graham, an ex post facto law is something that criminalizes conduct that would not have fallen under the law when it was committed. It increases the burden of punishment for a crime after its commission. It deprives one charge of a crime of a defense that was available when it was committed, right? So if you apply those standards and you look at, we've got 50 years of precedent, arguably 100 years of precedent, right? That says this single person would be a defense, right? And it was a defense. It was such a defense that the court dismissed it for probable cause. Knorr comes along and says, hey, we're changing this rule.
And just so we're clear on your ex post facto argument, the statute murder in the third degree, as it exists now, and as the state is attempting to add, the language has not been changed since May 25th, 2020, when this incident happened. Would you agree with that?
I would, but case law can, under federal law at least, case law can also be the basis for an ex post facto.
Okay.
That is Stevens versus Thomas is an example. Stevens versus Thomas, 19 Federal 3rd, 498, 10th Circuit, 1994. So under federal law, an interpretation or a novel interpretation of case law can create an ex post facto challenge. And then finally, Your Honor, the last thing is simply under Baxter, right? Baxter was a case that I'm familiar with. Baxter, we show up for the day of trial, right? I mean, we're literally now, in this case, we're in the middle of selecting a jury. We show up in Baxter for the day of trial, and they file a motion to amend the complaint, right? And the court denied that. It got appealed. And in Baxter, they specifically say that even though the state has the ability and has great discretion to amend the complaint, the court retains its inherent authority and its inherent discretion. And so even under Baxter, you still have the ability to deny this motion.
All right. Mr. Cahill, I'd like you to address, if you could, both the ex post facto and the inherent judicial authority arguments.
Sure. I think first it's just important to note that my friend on the other side isn't really making a prejudice argument, which is consistent with his briefing before. That's the typical reason why a motion to amend would be denied, and I don't think it's available here. And so we're left with the arguments that he's made. With respect to ex post facto, I think there are several problems with that. I mean, first of all, the ex post facto clause can only be violated by the legislature, and to the extent that so, given that, as you were saying, Your Honor, there's already a third-degree murder statute, it would require a complete, unpredictable departure from law. And this is the opposite of that. I mean, this one-person rule goes back 100 years to 1896, and most importantly, there was an on-point, unpublished Court of Appeals opinion in the Patton case in 2000, which does exactly what, the legal theory that we've embraced here, that Knorr has embraced, and the like.
Would you at least agree that it was being discussed a lot and it was a bit murky?
Your Honor, I don't know that we would agree with that. I think, for reasons that are briefed to the Court of Appeals explained, I think those cases are about actually intent to kill, not one person versus many. We understand you had a different view of that, but I don't think that we would say that it's murky. But even if it were murky, that's not an ex post facto violation. I mean, the idea that Officer Chauvin would have been surprised by it, act in reliance on existing law or something, would be pretty ludicrous. I mean, this has been, even if you think there was any doubt in Minnesota, it has been the law in many, many places, and the Lefebvre Treatise makes this very clear. But I certainly don't think that it's an ex post facto violation to apply something. Indeed, that would make the 2000 Court of Appeals decision also an ex post facto.
All right.
You had also said right at the end of when I was speaking the first time that you had understood the Court of Appeals to permit you to examine new arguments. And I think, with respect, I think that overreads what the Court of Appeals said. I don't think that they repudiated the traditional forfeiture rule, which is, quote, the well-settled rule that a defendant is not entitled to raise issues already decided on appeal or which are known and not raised on the first appeal. That's State versus Andren from the Supreme Court. I think what the Court of Appeals was saying was, look, if there's good cause for some new argument that hasn't been made, okay, fine. I don't think that that anything today rises to that level. So the first thing that my friend on the other side said is that Knorr was factually distinguishable. And as I was saying before, I think you've already rejected that argument at page 3 of its order. But just on the merits, I think, major points for creativity to Mr. Nelson, but this theory is nowhere in Knorr, and I think that was what your question to him was getting at. I mean, at page 4 of the Knorr opinion, the court said that Knorr argues the conviction under 195A can't be sustained if the alleged conduct was directed at a particular person. Knorr contends the evidence showing his death-causing act was directed at a person who appeared outside the squad car, and he can't be convicted of third-degree murder. The court didn't say anything like, oh, he endangered many people. Instead, at page 7, the holding is, quote, we therefore hold a conviction for third-degree murder under 195A may be sustained even if the death-causing act was directed at a single person. There's nothing in the legal analysis in Knorr that mentions that the cop put anyone else in danger. Indeed, that language about the silhouette that Mr. Nelson is referring to wasn't even language by Mr. Knorr, it was language by Mr. Knorr's partner. And even the dissent by Judge Johnson agreed with those facts. And so that's why we think this case is just like the cases in the Lefebvre Treatise that Knorr favorably cited, playing Russian roulette with one person, shaking an infant, throwing a beer at someone carrying an oil lamp, or, it's an unusual fact pattern, but all of those are examples of a depraved heart. And, more than a century of precedent, as I said, since the Lowe case in 1896 says that, it isn't necessary that more than one person was or might have been put in jeopardy. That's this case. My friend made some points. He said that it was procedurally different. And again, I think your order at page 3 rejected those arguments. And I think that the only way he gets there is by quoting 2 sentences from Noor, but not what comes next at page 6. And I'm happy to walk through it, but I think page 6, I think, answers that claim. And with respect to cases like Middich and the other cases that he cited, Zumberg, all of those are cases that I think are very clear. Middich says that they affirmed the third-degree murder charge, even though the defendant's shots, quote, were directed with particularity at the victim, at a single person. And that's how later cases like State versus Wahlberg characterize it. To the extent there's any doubt in your mind, we'd be happy to brief this and go through the facts of those cases. But we don't think it's necessary. We think, at the end of the day, this is very much like State versus Nelson, it's an even easier case than State versus Nelson. There, on the very day of trial, there was an amendment that was granted to add kidnapping charges when there was already a sexual offense charge, and that's two distinct offenses. Here, the difference between third-degree murder and second-degree manslaughter is very much one of degree. It's just about how depraved and dangerous the defendant was. And the defendant's answer to both charges is the same. He's saying, I acted properly. And if the Court of Appeals in Nelson versus State allowed the adding of kidnapping to a sexual offense claim, we think that this is far, far easier. My friend talks about Baxter, but I think he misses 2 things about it. First is, it was a Court of Appeals decision, and the Court of Appeals was just reviewing the district court for an abuse of discretion. The court was just saying it's permissible to deny an amendment on the morning of trial, not that it had to. And that just is a second point. You couldn't have more different facts. The defendant there had made a speedy trial demand, unlike here. The state waited until the morning of the trial to amend the complaint. They waited to interview the witness for 1 month, and the delay there was extreme. And through, the Baxter decision says it's about timing. It's about the fact that this was really done at the last minute when the state had opportunity after opportunity to do so. Here, we've moved with dispatch, in order to bring this to you.
You wish to be heard again? All right. With regard to the state's motion to reinstate, the court is going to grant the motion to reinstate, and I want to go a little bit at length addressing it. In reading, obviously, the Noor opinion came out, and it was very clear that I disagreed with it, said so, denied the motion initially because of my disagreement, but not without first checking to see if I was duty-bound to follow it as precedent. And now, based on the defendant's appeal, this Court of Appeals has made it very clear, yes, I was bound from the moment the opinion was filed, and I accept that. I even agree with the decision in State versus Chauvin that their opinions have precedential value immediately. And I want to explain why, because I did not believe so before. My concern is how the Court of Appeals got to that position. They stated in their analysis that the plain language of the rule says that precedential opinions take immediate effect. That implies that this court disregarded plain language in the rules, or at worst, was too lazy to look up the rules. Neither is the case. Upon reading the Noor opinion, realizing its application to this case, this court immediately turned to the rules to look for plain language as to when opinions that are marked as precedential have in fact that precedential effect. We found silence, not plain language. I think the Court of Appeals reaches too far by saying there's plain language in the rules. There is silence. There is not language prohibiting or saying that it is entered at judgment or that it takes effect immediately, but it is silence. And I think what the Court of Appeals has inferred from the silence is that opinions take immediate effect when filed. I accept that because of my second reason. Despite my disagreeing with them that the plain language is there, it is my belief and an analysis that Courts have inherent judicial authority to say when their opinions have effect. If the Court of Appeals believes that their precedential opinions, they get to decide when they're going to file it, how they're going to file it, whether it's an order opinion or more extensive. That is in the rules. There is plain language about that. But clearly every court has inherent judicial authority to decide when their opinions will be effective. Because the rules were silent, in this court's view, our next step is to look for case law. And we found Collins, which said it does not have precedential value until judgment is entered. The state has successfully argued to the Court of Appeals that that was dictum in Collins and did not establish the principle that the opinions take precedential effect immediately. And I accept that. That is their ruling. And based on that, I think the inherent judicial authority, there is that authority to make that decision and to say, when we file a precedential opinion, it has immediate effect. I accept that now as a rule of law promulgated by the Court of Appeals due to its inherent judicial authority to make such pronouncements. Because no pronouncement was made to such effect by any court that I was able to find before the Chauvin opinion was filed, that is why I said that the precedential value did not attach until judgment, because that's what Collins said. District courts, I think, are more at risk to start calling Supreme Court pronouncements dictum and refusing to follow it because of that. I am granting the motion because although these cases are factually different, that is Noor and the case before us, I don't think it's a factual difference that weighs in favor of denying the motion to reinstate because of the language of Noor. Noor is very clear. When intent is directed at a single person, this is a legal principle that they have established now as precedent, then third degree may apply. Single acts directed at a single person fall within the gambit of murder in the third degree. And as he said, that was part of their holding. It is not dictum. Accordingly, I am bound by that. I have to apply the rule. Even though they are factually different, I have to follow the rule that the Court of Appeals has put in place, specifically that murder in the third degree applies even if the person's intent and acts are directed at a single person. I disagree with the state that the defense has forfeited any other grounds, and so that's why I'm permitting the other grounds to be argued, but I did not find them availing here. First of all, the ex post facto, the statute has not changed. It has remained the same for years, was the same as it is today as it was on May 25th of 2020. And finally, discretion. It is an abuse of discretion standard, but discretion can be abused. And I think when my ruling, both in the fall and lately, in denying the motion to reinstate, was based on a legal principle alone, not on the facts of the case. It was the facts of the case that this appeared to be an act directed towards a single person, and on that legal principle of the single person rule, this court granted a motion to dismiss for probable cause, denied the motion to reinstate, but now that the Court of Appeals has said in a precedential opinion, specifying the single person rule applies to third degree murder, I feel bound by that, and I feel it would be an abuse of discretion not to grant the motion. As a last comment, there are cases, in fact I have myself, I think it was trial before last, on a criminal sexual conduct case. The state came in on the day of trial asking to add an assault in the first degree charge, and it came out of left field. There's really no notice that that was going to be important, and since it was an assault in a criminal sexual conduct case, we were talking about different intents, different foci on the acts that were committed. And I denied the motion to amend because I thought it came out of left field, basically. And this case is different. This charge has not come out of left field. It was originally charged. I think the defense has been aware that the state will take every opportunity to try and add it back. The remedy is not to deny the motion to reinstate based on timeliness. It is to grant a motion for continuance if the defense can prove to me they are prejudiced by this ruling. So, murder in the third degree is reinstated as originally charged. In this case, this is not a decision as to the other 3 defendants who are set for trial at a later date, and we'll address that later. Mr. Nelson, anything? Are you ready to proceed?
I'm ready to proceed.
All right. No other requests?
No other requests.
All right. We'll then proceed. We're going to take a 10-minute break. Do we have other motions in limine you wish to address today, or should we?
Yeah, I think we can. If I can just make a brief record on the motions. It's just a kind of a scheduling plan.
Sure.
So, Your Honor, I spoke with Mr. Frank last night, and I think we're both in agreement that there is state's motion number 2 and number 6 remaining, and 4 defense motions remaining. 3 of the total motions are dealing with expert testimony and things of that nature. So we were proposing that what we would do, as we discussed yesterday, would be to put together a flash drive with all of the expert reports for the court to review in camera and keep under seal, that you would have over the weekend to review those reports so that when we're making these arguments, it's not
in a vacuum.
Not in a vacuum, exactly. And then we'd like to, so we'd give you over the weekend, like we're granting you the weekend, Your Honor, to review these reports, but address those issues on Monday.
And that makes perfect sense.
Yep.
So I think we'll address those on Monday.
Yep. And then there's one of the other remaining motions we would also ask to put on Monday, and that has to do with the continued request regarding the previous arrest of Mr. Floyd. I know that we have to supplement that. We will also prepare a flash drive for the court to turn in with all of the documents pertaining to that for you to review, so that again, when we're talking about this, it would not be in a vacuum.
Well, and I think for the Spriegel motion that we handled back in September, I did review most of that, including the body cams.
So one point on that is, I believe that that motion was made in one of the co-defendants' case, and we may have joined in on it. So I just want to make sure that there is a record in this case.
Oh, and I'm not saying that you waived it or anything.
Yeah,
It's been decided.
So but there is also additional information that I think has come to light subsequent to that decision that the court should be aware of. Okay.
Does that schedule work for the state, Mr. Frank?
Yes, Your Honor. And I think what we're asking the court to do is to receive those items not as exhibits offered at a hearing or anything of that nature, but truly as a matter for in-camera review, to inform the court about the issues to be raised publicly in the motions, but to have that background available, and would ask the court, if necessary, to make the findings that in-camera review is appropriate for that, because there has been no determination made yet about admissibility of anything in those reports. And that really not just the expert matters, but the other 404B incident as well regarding that.
I think it's all appropriate, and so I'm going to receive them for in-camera review. They are not going to be filed with the court and thus not available publicly. So let's proceed on that basis with Monday with those 2 issues, the experts and the May 16th.
And that leaves 2 remaining issues, I think, one of which we can get rid of, I think, right now.
Okay.
And that is the state's, or excuse me, the defense motion number 36, relevant to Your Honor, what the motion was, and I can just simply say it was, we have made a motion to restrain or to prohibit the state from referencing civilian complaints regarding Mr. Chauvin. The state essentially agrees with us in their reply, with the exception of the 404B material that you've already offered. They just wanted that point of clarification. I think that's clarified. We're not
Anything that I've ruled admissible under 404B in our prior order is obviously admissible. The ruling for other complaints.
Right, you're right. I think our response was intended to seek this clarification that this motion is only about personnel matters, not the 404B incidents we had proposed to the court and the court had already ruled on.
Right. And for example, the personnel decisions that might have been made, again, and any findings that were made aren't really admissible. It's about the facts themselves of the incident.
That is true.
Okay. And that is certainly admissible based on the court's ruling.
Right.
Okay, I think we're all on the same page.
Yeah, simply there's no reference to any civilian
Right.
complaints. It's personnel issues. That was the point.
What I take the defense motion as is you will, or you don't want the state to say, well, are you aware that Mr. Chauvin had X complaints before this date?
Right.
Is that correct?
Correct, Your Honor. And the results of any of those, we are.
Right. All right.
I think we're on the
Okay.
same page.
Yeah, so then, so for purposes of, again, scheduling tomorrow, being Friday, I don't know that we will need this. It leaves only issue number 6 of the state, which is some training materials, but I think that we had kind of agreed to reserve those because we're working on which materials are coming in.
Right.
So tomorrow,
We don't have to be here at 8 a.m.?
it'd be nice, unless you are.
I've been working you guys pretty hard, so I agree. Let's start it. And the jurors are getting in. We have a nice rhythm with them on getting here by 8:30, seeing the orientation video and everything else. So I'm not going to bring them in earlier. The court schedule was not to have an 8 a.m. start. It was only to accommodate the motions and eliminate. So we'll start at 9 o'clock tomorrow.
Thank you, Judge.
Your Honor,
Mr. Frank.
the state would like to make a record about the trial proceedings over the last couple of days, given the pendency of several levels of appellate review. And I don't know if the court would like to do that after the recess. We have
Oh, you can go ahead and make it now.
What we're asking the court to do, Your Honor, because of the pendency of the appeals and what seemed like technical matters that lead to really problematic potential appeal issues later about the court's jurisdiction, we proceeded with some uncertainty, I think is a good way to summarize it. Uncertainty that we have always feared, and I hope we expressed correctly to the court early on, that jurisdiction of the court can be raised at any time, which means it could be raised in an appeal a year from now, and it's something that can't be waived. And because jurisdiction goes to the power of the court to adjudicate, to do its functions. So we have proceeded with some decisions in jury selection and motions that there is some dispute, as you know, about whether the court had authority to do that while those appeals were pending. Because maybe murky, we can borrow the court's earlier word, because it is somewhat murky about that. What we would be asking the court to do is to make a record essentially ratifying the decisions the court has made, now that we know for certain the court has authority to do that. So the court has, the court has made some rulings about motions in limine, but more importantly has made decisions about qualifications of jurors. And so we are asking two things. We're asking, first of all, for Mr. Nelson and his client to waive any challenge that he would have to the qualifications, the decisions the court has made, the qualifications and seating of those jurors, and also to have the court make a record that the court would not have done anything differently had this appellate issue been resolved Monday morning instead of yesterday evening, and that all the jurors seated, the court still agrees, are qualified based on the voir dire conducted by the parties and the decisions made by the court. That's the approach we're asking the court to do to really shore up this potential future issue.
Refresh my memory, though. The appeal, the latest.
Not the appeal of the reinstatement, but the appeal / writ of prohibition request that you made this week to the Court of Appeals was tell the district court to stop because we have concerns about jurisdiction. And their response was, based on subsequent events, your motion is now moot. They did not say, am I correct? It's moot, and oh, by the way, start over because there was no jurisdiction for what you did before we filed this order.
That is true.
Okay.
I just wanted to make that clear that I read the order appropriately. I think there's an inference there, although I'm much more happy with plain language than inference. But I think there is an inference there that that the Court of Appeals agreed that there was jurisdiction because we did avoid the third-degree murder issue completely. I didn't even entertain argument or hearing, but we did go forward with jury selection. So, Mr. Nelson, what record would you like to make?
Your Honor, I would just simply note that at the time, we were not making a jurisdictional challenge. I thought that the court had jurisdiction as to the second degree and the manslaughter charges, and that the only question that lacked jurisdiction was the question of the third degree murder. So the Court of Appeals and the Supreme Court have spoken, and I don't think there's any lack of clarity on that issue at this point. So I concur. We've proceeded on, I believe that the court had jurisdiction over two charges. It's no jurisdictional challenge other than on the third degree, which again is now resolved. So I, on behalf of my client, am confident in the decisions that this court has made thus far, both as to motions in limine as well as qualifications of jurors. I'm not seeking to restart the process.
Before we began on Monday,
I think I even made the specific finding that I believe I have jurisdiction for everything outside of the third-degree murder, despite the state's arguments that it might affect other parts of the case. So I think we've made a sufficient record as far as that goes, but I'll make one more record. Lest the Court of Appeals thinks that I am intensely incorrigible, I did agree with some of their analysis in this case. I ultimately did agree with their final ruling because of, I believe they have the inherent judicial authority to do so. But even if I had not agreed with any part of the analysis or did not believe or totally disagreed with their result, I acknowledge that it was a precedential opinion and law of the case, and I would have been duty-bound to follow it regardless of any misgivings that I have about the analysis. And like I said, I agree with their result, just not how they got there. And I'm not that incorrigible that I would completely ignore the Court of Appeals and their pronouncements. That being said, I think we're good until Monday as far as motions. Okay, I'm gonna let's do a break until 5 minutes, Sue. So 8:55, we'll see if we have the next juror and we'll proceed. Okay, apparently Mr. Schaefer says we do. All right, we're in recess until 8:55.